This video extends the lesson, Day 9, Helsinki, Update Personal Data, and contains a comment of the document. Resolution on the protection of the privacy of individuals vis-à-vis electronic data banks in the private sector and other relevant GDPR referrals. Please, find in the description below references for the course. The Council of Europe recommended, in 1973, that inaccurate information should be corrected in the context of data compiled in electronic data banks, resolution on the protection of the privacy of individuals vis-à-vis electronic data banks in the private sector. So, it is not surprising that the European Union 2016 General Data Protection Regulation provides a right to rectification. The surprise comes from the absence of guidance regarding the rights and responsibilities related to that right exercise. A person may ask the controller to rectify inaccurate personal data concerning him or her. The controller must proceed to that rectification without undue delay and free of charge, Recital 59. The right extends to complete incomplete data, a person being allowed to produce a supplementary statement to this end. In that event, the controller can accept or refuse the modification depending on the processing purposes. The GDPR does not define inaccurate personal data. Still, the Court of Justice of the European Union excludes that the right to rectification extends to allowing a person to correct an incorrect answer to an exam, Novak. It does not mean that a person cannot ask to rectify a response or an examiner's comment regarding the exam that does not accurately reflect the candidate's original answer. It can happen if, for example, copies were mixed up, and another candidate's answers were ascribed to the candidate concerned, Novak. The possibility of completing or rectifying inaccurate or incomplete information can also be invoked in the context of profiling, i.e. when a company establishes employees or users' profiles for different reasons, advertising, marketing, work performance, and so on. It is the case where it uses personal data, usually through automated processing, to make decisions concerning them or to analyze or predict their personal preferences, behaviors or attitudes, Article 4, and Recital 24. A profiled person may use her/his right to access, Article 15, to learn what information was used to create the profile and the content of the profile itself. The right to rectification would allow her/him to amend, change or update any inaccuracies discovered, guidelines on automated individual decision-making and profiling. A person might have been included in a category, for example, that does not correspond to her/his ability to perform a task at work or is irrelevant to her/his health condition. The person may challenge the accuracy of the information used and the result, that is to say, the profile itself, guidelines on automated individual decision-making and profiling.